6,000 adoptions take place in Australia every year, an average of about 115 a week, or over 16 every day. With most of them, there's a scene something like this. The nervous and proud parents-to-be at the hospital nursery, about to claim this young life as their own. To them, a life conceived from the union of strangers, born from the womb of another, and yet a human being soon to be recognized by law and society as wholly theirs forevermore. While many words on adoption have been written in places like the United Kingdom and the United States, hardly anything has been published in Australia, due largely, it seems, to conflict between the various states on how adoption should be carried out. For example, this Sydney couple, under New South Wales law, had the choice of adopting their baby through the Child Welfare Department or through one of several licensed private agencies, generally run by church organisations. A third method, where, say, the natural mother's family doctor or solicitor would find new parents for the child, has been outlawed under new state legislation. This procedure, known as private adoption between unrelated parties, is, however, still legal in some other parts of Australia. I wondered why it was New South Wales had decided to do away with a method which was being retained in 3 other states. Mr. W. Langshaw, the department's deputy director, said these purely private adoptions have been banned in order to give proper protection to the 3 parties to an adoption: the child, the natural parents, and the adoptive parents.
The child deserves to find a home where he will have a happy, loving family. The mother who's surrendering the child needs to have full opportunity to discuss all the pros and cons of surrendering or not surrendering the child, and she needs to be confident that the child will be placed in a good home. And thirdly, the adoptive parents also need to be sure that the child is free for adoption, that it will be a permanent placement.
In the office of Sydney solicitor Ian Harvey, I saw some of the legal complexities of adoption. How some states, for example, didn't recognise others' adoption orders. This will soon change. So too will the law on parental consent.
The court may decide that the natural parent of the child is for some reason not a fit person to have the child, and so in that case the court can order that that particular parent's consent be dispensed with. In the case of legitimate children, the consent of both parents is required. In the case of illegitimate children, the consent only of the mother is required.
In your connection with some of the voluntary adoption agencies, what do you say about the standards set by the state for those wanting to adopt?
Well, I'd be the first to admit that the state have a very good standard, but I think that sometimes the arbitrary standard can work a hardship on the part of some suitable applicants for adoption. The adopting mother might have a blood pressure, and this can be a fairly important factor in her whole medical health, but sometimes